Recording in progress.
Good morning as everybody starts piling in.
Good morning. Good morning.
Good morning. We're just waiting for a ton of people to show up. I'm going to continue to let people in. We have a lot of you joining today. Welcome, HomeLife members. And we have more. Welcome, welcome, welcome. And we got more and more and more. Folks, I'm gonna, hi, my name is Chris. As many of you may know me, many may not. However, we do a lot of the webinars and training, myself and Gabrielle. Gabrielle, the main person to do it. I'm hoping everybody can hear me. So if you can, I just want to make sure in the reactions button or those wonderful emojis, please feel free to click them and show me that thumbs up, or in the chat room say a little good morning or that you can hear us. In the meantime, I'm going to continue with a little bit of housekeeping. In the chat area specifically, sorry, I'm clicking and letting more in as they come. In the chat area specifically, folks, what we're going to do today is that's where Mr. Weisletter will handle questions at the end of the session today. So please try to refrain from putting other comments in the chat area or anything like that. We want to be able to find all of the actual chat, all of the actual questions. So please try to keep it to just questions in the chat area. I will monitor that and we'll get to all of those questions at the end. Today we have Mr. Weisletter and Gabrielle Jeans, our Dean of University, here to let you know about our course.
I'm very excited today to introduce Mark Weisletter. Is a senior partner at realestatelawyers.ca. Mark is recognized as a real estate industry expert on all real estate issues, having spoken for the real estate associations, boards, and brokerages across Canada. Mark is a regular guest expert on BNN, Global News, City TV, CTV, your morning news programs, and has written columns for the Toronto Star, Real Estate Magazine on real estate issues. Mark has also been a best-selling industry book writer for real estate agents, buyers, sellers, and landlords. What an exciting guest we have today. Welcome, Mark Weisletter, and thank you very much from all of us at HomeLife. Welcome.
Thank you. Thank you very much. So I know that the topic is timely and a lot of people have questions, but I'm going to ask you to let me go through the material because I think I'm going to answer all your questions or most of them through the material. But if you have any questions, you can chat them in. I will answer the chat questions at the end and I will stay on. I'm trying to finish my material a little bit early, so there'll be plenty of time to answer all your questions. So with that, I'm going to get started and welcome everybody. Thank you for the introduction. I have been doing this for a long time. I'm a guest real estate expert on TV and radio. I'm quoted by all the national newspapers, and I'm a senior partner with realestatelawyers.ca. These are the books that I've published, including my updated landlord guide, which has been updated for Ontario. And I have a new book coming out on Audible later on this summer, which I think everyone will find extremely helpful. A little bit about our firm. As a result of the pandemic, we now sign up over 90% of our clients in a Zoom meeting using DocuSign. And so the client never has to travel. if the client is elderly or has difficulties with Zoom, we will still go to the client in person to sign up all the paperwork, and we can close a deal in every city in Ontario. So it doesn't matter where you are, we can close the deal. And we've always believed in paying real estate commission by EFT, and that's how we pay our seller. So the money is in their bank account without a hold the day after closing. And to my knowledge, we are the only law firm in Ontario, maybe Canada, that is a bill payment. So in other words, what that means is the way you pay a hydro bill online, that's how buyers put the money in my trust account to pay the down payment at closing. In other words, there's no wiring charges, there's no lining up with a mask at a bank for a bank draft. It's incredibly easy for a buyer to close a deal with our firm. If you sent a deal to me before, you know you get an email the moment the deal is registered. The client gets a complete report on the day of closing. And we've been putting a lockbox on seller homes for years before the pandemic, because we just thought it made common sense that once the buyer lawyer gives us the closing money, we give them the code and the buyer just goes to the home and picks up keys. Now I'm delighted that more and more people, because of the pandemic, are arranging for a similar safe exchange of keys on closing. And I'm always available. I must get dozens of questions on landlord tenant and all other issues, tax issues every day. Just send me an email if you need help. People ask me about our fees. I say, go to our website and you'll see our fees. It's very transparent, but I still agree to match any other quote as long as it's in writing so I can see all the details. I put a disclaimer here because I don't want you to be lawyers. This is complicated. I put a toll-free number, a direct number, and my email. If you have any questions, please just send them to me. Okay, so we're going to start with the most recent changes that happened last summer. And the big changes were penalties, number one. So in other words, if you take advantage of a tenant, the penalties are high. And the number one method that landlords would take advantage of tenants was the N12. And the N12 is the form you use if you're going to either move in yourself or sell to a buyer who's moving in. But the form was abused. In other words, it was used to trick tenants into leaving when all you really wanted to do was resell it to somebody else for more money. And so now there's a potential $50,000 fine to the government if you do that. In addition, if you are selling to a buyer who's moving in, they've now made it law that you have to pay that 1 month compensation as well. Before, you only paid the 1 month compensation if you were moving back yourself. Now you have to pay it even if you're selling to a buyer who's moving in. And in addition, the tenant can now sue you for 12 months rent if they prove that you tricked them. In other words, you promised to move in, you stayed for 2 to 3 months, and then you left, or you sold it, or you rented it to somebody else. Now you can be sued for an additional 12 months rent as a penalty. And the landlord also has to swear that they haven't done an N12 with any other unit in Ontario in the last 2 years, because many landlords were playing this game at multiple properties. So you see, they made these changes to try to stop landlords from tricking tenants. So now I want to take you through a typical non-rental application. Let's say it started today. So tenant hasn't paid the rent in June. You issue the N4, no difference. You got to give them 14 days to pay. So if you did it on June 10th, you give them till June 24th to pay. If they don't pay, you have to file for a hearing. That's the L1. You got to pay another $170 and you wait for a hearing. That's where the first problem happens. Could take 2 to 3 months, sometimes 4 to 6 months to get a hearing because of the backlog at the board. However, now, instead of waiting for a hearing, they've got this new thing called a payment agreement. So this is an agreement you can get from the board website. It's like a settlement agreement. So it says you and the tenant say, we're going to make a deal. Instead of waiting for a hearing, you're agreeing to pay me X dollars a month plus an additional amount to catch up. And so we're all good. It's like a settlement. And then what you do is you send the agreement by fax to the board saying, hey, guess what? We made a settlement. And it's signed. So now the board will cancel the hearing and it'll be like you had an order from a judge. And that's what happens. Now, let's say the tenant then breaks the agreement. So they agree to pay you, 2 months later, they break it. Well, now you can actually get an eviction order without a hearing. Without a hearing, you just say, hey, we had this deal, they broke the deal, give us an eviction. You can do this today. But the tenant can still fight this. So if they say that you forged his signature or he was tricked, you can still fight, but many don't. So I want to repeat, you can get an eviction order today for any reason. However, the sheriff, that's the last part of an eviction. Only the sheriff in Ontario can physically go to the house with the court order and say, get out. And right now, since the beginning of the pandemic, the province has said no enforcement of evictions. I'll repeat, even if you have an order, the sheriff is not coming and they are not going to evict anyone until the lockdown ends. The good news is we do see light at the end of the tunnel. More and more people getting vaccinated. We're moving into step 1, step 2. One of these steps, the province is going to say, we're going to allow evictions to be enforced as well. And at that moment, you'll be able to go to the sheriff to physically evict somebody. So I say to people, get the order if you can, because the sheriff will be back in business soon. And that is how you complete any eviction. So we're just going to have to wait. Some cities are going to open up before others. So evictions are going to open up in those cities before others. So you can still collect money. Let's say the tenant runs away. So let's say the tenant runs away and they owe you $5,000. You can still collect it. You can go to the landlord and tenant board. You can go to small claims court. The difficulty is, are you going to find the tenant to collect the money? That's a different situation. Are you going to be able to enforce it? But you can definitely sue the tenant for the money after they're evicted as well. I always say to use an experienced paralegal because there are time limits. You have to complete forms correctly. And if you make a mistake, you could find out about the mistake 4 months later. And a judge says, well, you made a mistake when you sent out the first form. So you're going to have to start again. I've seen this too many times. So don't do this yourself. Get help. Make sure your client has help so that at least you do the process correctly. Now, I just want to take you back because for the last 30 years, we've already had the N11 process. So the N11 is the deal where a landlord and tenant, usually in exchange for money, the tenant just agrees to leave early. We've always had this, well before the pandemic. And if the tenant signed it and then refused to leave, you could also get an eviction without a hearing. This was always available. So you see, and the tenant could dispute. So you see, there's no real difference between this new payment agreement and then get an eviction order or the old N11. So the problem is today, let's say the tenant did sign the N11 saying, I'm leaving today, and you pay him money. They could still say, I changed my mind. And now you got to go get an eviction order, and there's no sheriff to throw them out. And I have seen situations where the tenant has taken money, signed an N11, and then said, I'm sorry, I can't find a place to move to. I signed it under pressure. I'm not going anywhere. And even if you're right the sheriff will not evict them. And there's still a ton of backlog at the board. So even if they come out of lockdown, it's still going to take you time. And so the best advice I'm going to give you for all this stuff is right here. Just write a check. You want the tenant out? Write a check, but give them the check on the day they leave, not in advance. People say to me, how much? There's no formula. I've seen some tenants ask for 1 year rent, some tenants ask for 2 years rent. My advice, whatever it takes, is still a better deal, because I have seen some tenants delay this for over a year, even before the pandemic. And so you want the tenant out, you want to sell this property. The landlord's not going to want to hear this, but that's the advice I give. Now, as we come out of lockdown and evictions start to speed up, this will change. Then things can work out a little bit better. Now I want to talk a little bit about the government lease. As you know, that there was a government lease and now it's a new one that started March the 1st. So you must use the new one, not the one from a couple of years ago. The new one you have to use. And the main difference is all the changes from a year ago that I just talked about, the N12, they've been put into the new government lease. That's why you have to use the new government lease. So you're supposed to give it to the tenant before the tenant moves in. I repeat, before they move into the unit. So let's say you signed a Form 400 lease today with the tenant, which, you know, has all the brokerage and all the other stuff, and the tenant's moving in July the 1st. And they signed a 1 year lease. But you didn't give them the government lease. Now, as far as the tenant's concerned, they could stay there for a year. You can't throw them out. However, now let's say after July the 1st, the tenant says, I want the government lease. And you don't give it to them. If you don't give it to them within 21 days, they can actually not pay August rent and you'll never get it back. That's the penalty. But it gets worse. Even if you give the lease on time, let's say you gave the lease by July 15th. Let's say the tenant doesn't like you. They don't like the way you take care of the place. They're not getting along. They could just turn around and cancel the lease by giving you 60 days notice. So this tenant that signed the lease on July the 1st, he can just give you notice now and say, end of September, I'm leaving. And there's nothing the landlord can do about that. And during the pandemic, a lot of universities went to remote learning. And I got calls from people everywhere, parents, they guaranteed kids leases. And the landlord said, you got to pay. We don't care if the university is going remote. I asked the simple question, did you sign the government lease? And when the parents said, no, they didn't give us the government lease, I got them out of all those leases, 60 days notice. But where they signed the government lease, I said, there's not much you can do unless you could find somebody to sublet it to. There was nothing you can do. So I wanted to highlight why, when you're acting for a landlord, you must get that lease done. Now, it's 14 pages instead of 13 pages. That's the main difference between the two leases. You should always also complete section 3 of the government lease because it has the email contact. And then you can give notices for showing by email. So you got to have that in the lease. So then you could give notices for showings. But you also must understand you cannot serve an eviction notice by email. It's not legal. That's a mistake people make, for example, when they don't use professionals to help them. You have to serve it in person. You can serve it even by mail. You just postmark it, but you can't do it by email. And you can still add clauses to the government lease as long as they're legal. I have dozens of clauses in my landlord guide that people can use. So here are some examples. And all of you are getting a copy of this deck. It's recorded. I will also be sending it in and they'll be distributing it. as well. So here's my clause about no smoking, marijuana, cigarettes. You can put that in the lease. It's legal. First and last month's rent. The government lease only allows you to take the last month's rent. I've worded a clause so that you can actually take the first and the last month's rent, but it's at the time the landlord accepts the lease. But be very careful. If you ask for 1 year's rent in advance, it's not legal. If the tenant offers you 1 year rent in advance, it's legal. And it's not always easy to tell the difference, because many times tenants will pay it and then say that the landlord demanded it or they wouldn't give them the place. And then it becomes, who are you going to believe? So to me, if you're in a bidding war, and there are bidding wars for rentals, if somebody offers you rent up front and you have other leases that don't, then you keep those other leases, because that's good proof that it was the tenant that offered the money in advance. You can't ask for it. You can't have a text. You can't have an email that even suggests the tenant pay upfront rent. No Airbnb. A lot of landlords don't like it. When tenants sublet or put their place on Airbnb, put a clause that says you can't do that. So, summarizing, when you act for a landlord, so your landlord doesn't have any problems, you'll ask the tenant agent, of course, to complete the Form 400 because it has all the brokerage information to get paid commission. You have to do that. Then you'll tell them, while you're at it, do the government lease too. Fill it in. Let them fill in the government lease. Then you might have a Schedule B, like you do on houses. You have a Schedule B. Why not have a Schedule B saying, here, add these clauses, no smoking, no Airbnb, put them in as another schedule. Then you take the whole package to the landlord, sign it, and there's no negative things that can happen. A tenant is there, it can't cancel. But you see, if you're acting for a tenant, I would only sign the Form 400. I wouldn't volunteer to sign anything, because this way the tenant is protected. You can't evict them before the end of the year. But if they're not happy for any reason, they just have to ask for the government lease and then give 60 days notice to cancel. So that's, you see, it's different when you're acting for a landlord or a tenant, because the tenant can then change their mind and just leave without any penalty whatsoever. What happens if the landlord wants to change their mind? So let's go back to the example I give. The landlord signs the offer right now. They take the first and last month's rent, and it's supposed to start July the 1st. Then, before July 1st, the landlord finds out all these terrible things about the tenant. And I've got many calls. Landlord says, what do I do? I'm afraid to give this person the keys. Do I have to give the key? I took first and last month's rent. Can I just give him back the money? I'm asked this all the time. So I say, yeah, you can cancel. You can give him back the money, but the tenant can sue you, because now the tenant has damages. They have to store their stuff. They may have to stay someplace short term. They may have to find another place and pay more rent. These are all damages that the tenant can sue the landlord. So really, what I say to the landlord is, you have two choices. They're both no good. Either you get sued by the tenant, or you give the keys and you're terrified you're never going to get paid the rent. What do you want to do? Many landlords say, you know what? Let the tenant sue me. I'll settle it later, because I just can't live like this. And it's similar, that discussions I have to have whenever buyers can't close. What are the options for sellers? What side I'm on? I have to put all the options out there so people understand, all their rights. So you can't increase the rent on anybody this year. Doesn't matter when the unit was built, rents are frozen, no increase. The only exception is if the tenant leaves on their own. So if the tenant just leaves on their own, then you can raise the rent to whatever you want on a new tenant. Now for next year, we have no idea yet if they're going to allow rent increases. If they're going to allow it, they likely have to announce it before October the 1st, because you have to give 90 days notice. So if the lease started on January 1st, to give notice, you have to give the notice before October the 1st. So no word yet if they're going to allow an increase in rent next year. So now we come to the difficult, what I consider a major issue, is can you evict a tenant if you want to sell your home in advance? I get this all the time. The lease is over, it's a monthly tenant. How do I evict them so I can stage the place and fix it up and sell it for a good price? Well, too bad. There is no notice. But first, you have to look at the termination date in the lease. Because if the lease has a termination date, let's say of November 30th this year, you can't evict before November 30th. Now check for something else. What about renewal? Many leases have a right of renewal for the tenant, meaning the tenant can sit there another year. Now you can't evict them till the end of their renewal option. So it's very important when you get asked about this. Please let me see the lease so I can see how long the tenant has to stay there. So let's say it's a monthly lease. As I said earlier, one way to evict is the family reason. You're moving back yourself. You have to pay 1 month in compensation, but you have to stay there for a full year. So many landlords tell me, I don't want this. I need the tenant out. I have to fix it up and sell it. I'm not going to stay there for a year. Well, it's too bad. Then you can't use this method. The otherwise method is you have to sell to a buyer who is moving in on closing. That's the only other way. But then the seller says, well, wait a minute, I can't fix it up. Now I've got to sell it when the place is a mess because the tenant's going to keep it a mess. Too bad. Nothing you can do to stop that. And so this is why I said in the beginning, you want the tenant out? You want to stage the house and fix it up and make a lot more money? You got to write a check. Got to pay the compensation. Hopefully pay it on the day the tenant leaves. Move them out and then stage, list, show, sell. That's the way to do it. Now, showings. You can authorize a buyer or the listing agent, as you know, to do the showing. And it has to be with a potential buyer. Maximum time, 1 to 3 hours for a showing. Usually with the home inspection, you need the 3 hours. And as I said earlier, the notice for the showing can be given by email if the parties have that in their lease. So as you know, many tenants are refusing to permit showings during the pandemic. And I get the question all the time, can the tenant say, I'm too fragile, I'm old, I've got young kids, I need a negative test from everybody who's coming in the building, I need proof of 2 vaccinations, otherwise I'm not letting nobody in. So people ask me, can the tenant refuse? And my answer is, it'll take you 6 months to find out, because that's how long it will take to get a hearing to see if the tenant is being reasonable or not in refusing you a show. So you see, effectively, they can do whatever the hell they want. And that's why before you list, see if you can make a deal with the tenant for showings. Because if the tenant tells you right away, I'm not letting anybody in because of the pandemic, why are you even taking the listing? Just wasting your time. And so hopefully that answers the question. It doesn't matter if the tenant is right or wrong. It'll take you too long to find out. That's the problem right now. So let's say you want to sell a home with a tenant. Let's say it's a condominium. You have 3 possible buyers today. The tenant's not leaving. The buyer could be an investor who's accepting the tenant. That's buyer number 1. Buyer number 2 says, no, the rent's too low. I want vacant possession. I want to fix it up and double the rent. But right away, this looks illegal. But that's your buyer. That's what they want. And the third buyer says, well, my daughter will be living in this unit because she's going to college nearby. So those are your three potential buyers for this condominium. The first buyer is the best buyer because now the buyer just accepts the tenant and the tenant's happy. They can stay there. So you would just write a few clauses in the agreement. The buyer agrees to assume the tenant on closing. The seller will provide something in writing from the tenant that says, this is what I pay in rent. This is my last month's rent that I paid. And I have no claim against the landlord. So you would try to get that from the tenant, and you would put that in the agreement of purchase and sale. And then you would put another clause that just says the seller will tell the tenant after closing to make all the rent payable to the buyer. So this is the easiest buyer for you. The tenant's not upset. They can stay there as a tenant. Now we come to the second buyer. Remember the second buyer? They wanted the tenant out so they can double the rent themselves. Well, that's not legal. So you could do it. However, you would have to make it conditional. And it would be conditional on the seller making a deal with the tenant. So let's say this was a condo that was on the market for 400 and it's not a bidding war. And the buyer says, I'll pay you 420, even though it's not a bidding war, because I need vacant possession and I'm not moving in. So you see, the reason it's conditional is now we let the seller go to negotiate with the tenant and say, hey, I'll give you $10,000. Will you leave? If the tenant accepts it, now you close. And you see now the buyer doesn't have to move in and they can do whatever they want with the unit, but they have to pay off the tenant to do it. This is not easy, but that would be the only way to get that done. So now let's say we have the buyer whose daughter is going to move in on closing. So it is a reason, but we have to deal with reality right now, the lease and the environment we're in right now. So if the lease starts on the first day of the month, you have to give 60 days notice from an end of a month, at the end of a month. So let's say you're signing a deal today, June 18th, okay? And the tenant pays rent on the first of the month. They pay on the 1st of June, 1st of July, etc. So 60 days from today, the earliest you could evict is August 31st, because it has to be at the end of a month, at least 60 days from today. So August 31st is your termination date, and you would put that in the N12 notice. Now, I have seen when people do it themselves, they put the termination date as September the 1st. Guess what? Wrong. I've seen them put September 1st, then they end up in court 6 months later, and the judge says, wait a minute, you put the wrong date. That's the first day of the term, not the last day. Go start again. You have to start all over again. That's why I said you don't do it yourself. So now we can do a closing date of August 31st or early September. But remember, we think right now the tenant is leaving. And as I said earlier, they don't have to go anywhere, and there's no sheriff to throw them out today. So we have to pay 1 month compensation to the tenant anyways. And we could put in perhaps that we'll close earlier if the tenant vacates earlier. But we also have to say what's going to happen if the tenant doesn't leave on August 31st, because I just told you, they don't have to. Then you have to get a hearing, then you have to get a sheriff, and right now there's no sheriff. So here is the clause that many people have used. They've taken it from my landlord guide, and I've put it in here again, because I've tried to cover every situation that could arise. Now, some people have made changes to this. It's okay. But let's understand what it says. So it says right away, the buyer is moving in. They're not lying. They're moving in on closing, and the seller will give the 60-day notice using the N12. And the seller will pay the 1 month compensation. So you have to say that. And then I go on to say the buyer will provide whatever information is needed to prove that the buyer really is moving in. They usually have to sign an affidavit if this is going to go to court. It swears they're moving in. But I also say they have to indemnify the seller. So if the buyer's lying and their daughter is not really moving in, this is a trick. And remember, the seller could get penalized for that trick. Now the buyer has to pay the whole amount of any penalty. Then I go on to say, if the tenant disputes the notice, now what? Tenant's not going. Well, we'll extend it another 60 days. You could extend it more, but whenever people talk about extensions, you always have to worry about the buyer's mortgage. Are they going to lose their interest rate? Are they going to lose their financing when you do these extensions? But then I say, if we still can't close at the end with all the extensions, I put here the buyer has a choice. They can accept the tenant and finish the eviction, or they can just cancel the deal and get their money back. So I realize this is not easy, but you have to provide for this because this happens. I've had situations where it's taken a year to get the tenant out. Buyers have had to go live with their parents, and eventually it's been okay, but we don't know when tenants are going to be forced to get out today. We don't know that. So let's say before closing, the tenant's not going to leave. As soon as you give them the N12 today, August 31st, the tenant says, forget about it. I know my rights. I'm not going anywhere. Just, you can do whatever you like. This deal is not closing. So right away. What's the point? So I would right away be talking about, okay, maybe we'll give the buyer a credit. I've seen deals. I've negotiated deals where we gave the buyer a credit, $5,000, $8,000, and the buyer says, okay, I'll take the tenant. I'll do it myself. We're coming out of lockdown. We're going to get the hearing. We'll get them out. I'll do it myself. It's possible. So that's always a possibility you should look at right away. So let's say today you give the N12 for August 31st, and right away the tenant says, I'm not going. Don't wait till August 31st. Apply for a hearing today with a paralegal. It's very possible you may get that hearing before August 31st. If we come out of lockdown, I know the Premier has said they're going to appoint more adjudicators to the board to try to clear the backlog. So it's possible. You may not have to extend too long to get them out, but don't wait till August 31st. Get moving on it right away. However, when I get a deal in today and I'm acting for a buyer and it says seller will give the N12 to the tenant, I always say to the buyer, you may not get in. I don't care what the seller is saying to you. This tenant may not leave. And so I say right away to the buyer, do you have a place to go to if the seller needs an extension because the tenant changes their mind? I said, you've got to have a backup plan. You can't be on a moving truck and then find out the tenant's not leaving. So I have this conversation with the buyer right away on every purchase when I see that it's dependent on a tenant leaving. And I don't care if they say he signed an N11. So what? They could change their mind even after they sign an N11, and there's no sheriff to evict them right now. And as I said earlier, even before the pandemic, tenants who were professional, who knew the system with the appeals, they were delaying evictions for over a year, even before the pandemic. Now, I wanted to just give you this other idea, because with the offers that are coming in now, sometimes sellers want their money, but they say, we want to stay in the property for a couple of months after close. And buyers are happy to do that just to get the deal done. The problem is you can't call the seller a tenant, because I've seen that. I've seen offers where it says the seller agrees to rent the property back from the buyer for a few months after close. And then the seller says, you know what? I really don't want to go. So I'm going to continue as a month-to-month tenant. And if you want to evict me, you have to give me 60 days notice and pay me 1 month compensation. I've seen that happen. And when it happens, there's nothing the buyer can do. So what I've done is I've prepared some language for you, which I've given to agents to help you. So what you do is you create a very short license agreement. It's not a rental agreement at all, but it's got to be short. So let's say we were going to do it for 2 months. The buyer agrees to give the seller a temporary license to occupy the property for 2 months after closing on the following terms. The seller will pay a license fee, could be zero, could be whatever you want per month. The seller is responsible for maintenance, repairs, and utilities. The seller will vacate. Just put, let's say August 31st. Close now, seller vacates August 31st. And then the key, the seller has no rights as a tenant under the Residential Tenancy Act. So that's it. Now, what does it mean in English? It's temporary. The seller doesn't leave. On August 31st, you walk in and change the locks because the tenant is not a tenant. You're just a trespasser after August 31st. Think about what it's like when you stay in a hotel. Your time is up, they throw you out. Same thing. People have always said, can I use this for a year, Mark, and just make everything a license and then just throw every tenant out? That's why I said it has to be very short. Once you get over 2 to 3 months, a judge may say it's a lease anyways. So it's got to be very short, but this at least will protect the buyer. And I hope that helps you. So I hope that you have found this helpful today, the information. So now I'm going to stop my share, and I'm willing, if people have chatted any questions or they've maybe sent any questions to you, I hope you found this helpful, everybody, but I'll be happy to stay on the line and answer questions.
I see in the chat area there are a couple of questions. They didn't send me any questions to my email, so I'll just take a quick look here. The rent increase, what can we increase the rent this year? I think they missed when you said you can't increase rent this year and you're waiting for when to know about rent increases? Sorry?
Yes, we're waiting to see if the government will allow next year. There's no increase this year.
The rules, whoa, as things fly on me. The rules encourage tenants to misuse the LTB provisions. How investors will get motivated to come into the residential market to invest.
Through which rule? I don't understand the beginning.
I think it's the rules, the LTB provisions, like that the tenants are taking advantage of this situation and they're curious more along the lines of, you know, how can we get motivated investors in the residential condo market, I guess.
I think the premier is on the right track. He's going to open up. He's going to appoint more judges to deal with the backlog. And the point is, as we come out of lockdown, evictions can happen again. And once tenants actually face a sheriff coming, it'll be a lot easier to collect the rent and close deals. And I think investor confidence will go up too as a result.
Does your office handle landlord to tenant dispute that you have presented, and what are costs?
Yeah, as I said earlier, people call me all the time saying, you know, what are my chances of winning? What should I do? And I can tell them in 4 sentences what they should do, and that they don't need to waste thousands of dollars. I will typically refer people to a very good paralegal to assist them with most evictions. And if it's something a little bit more complicated, let's say it's an abuse situation, emergency situation, then I would refer them to a lawyer that only deals with litigation, landlord-tenant matters.
Next question here is, buyer says and signs an affidavit saying that they would be living at the new place, but actually they did not. Tenant has vacated. What are the ways that a tenant could find out that the new buyer did not move in, but leased out to someone else? Same thing on the listing side.
They watch. Tenants come around. They knock on the door. They're, they know that they can get a penalty. So they come and check. So it's very hard to fool a tenant. because they do come and check periodically during the lease.
I have a question here from Reza Shahab. What if the tenant agrees to increase? I'm not sure what that would be in regards
So
to.
I think what the question is, well, let's say people don't know you're not allowed to raise the rent this year, and they raise it anyways, and the tenant agrees. It's illegal still. It's still illegal, even if they agree.
Where can we find your guide for landlords?
Yeah, thank you. People just have to send me an email. It's mark@realestatelawyers.ca, and you could just order one through email with me, and I'll just send one out to you.
There's no doubt I learned a lot today. Mark is the best. I like that one.
Yeah, great one.
I heard there's a 1.2% increase allowed in 2022. Can I increase January 1st, 2022, since no increase for a whole year?
I have not heard that yet, but if it becomes official, you have to give tenants 90 days notice, which means as long as you give them notice before October 1st for next year, if it's legal, then you can raise the rent 1.2%, but I have not yet heard that number.
The next question is, would all this apply to a basement rental if the landlord lives upstairs?
I'm sorry, what's that about basement?
I'm not sure. Lila asked the question, would all of this apply to the basement rental if the landlord lives upstairs?
A basement apartment is an apartment. All the rules apply. Everything applies. And interestingly, if let's say the basement is an illegal basement apartment, you still cannot evict the tenant because it's an illegal basement apartment. You just got to make sure it's safe. And so that's not an excuse to evict a tenant either. So all the rules apply, whether it's a basement apartment or a regular apartment.
The new government lease form, it applies to new leases starting when, and does it apply to existing lease agreements?
The new government lease applies to any lease that starts March 1st, 2021 or later. So any lease that starts today, you have to use the new government lease. If you had a tenant that signed the old lease, let's say a year or two ago, and they're just on the monthly tenancy, you don't have to give them the new government lease. They can stay on whatever terms they had before March the 1st. It's only for brand new leases you have to use the government lease.
I like this one. How many times can we renew the license agreement for that seller or 10?
Yeah, sometimes I'm afraid when I give ideas and everybody gets to be a smart guy. You try this. I told you one time, and when a seller's renting back, there's there's a reason for this. It's a very unique circumstance. Otherwise, forget it. When you think about it, if you rent your place for 2 weeks to somebody on an Airbnb, and they tell you afterwards, you know what, I'm going to stay, they probably can. Even that 2 weeks could be considered a lease because there's no limit on a lease. It has to be so long to be a lease, So please, that license agreement is only to be considered when a seller wants to stay a little while after closing. Another situation could be, and I've seen this, where there's a problem with closing and the buyer has nowhere to go. So money's not paid, but the house is vacant. So they say, okay, we'll let the buyer move in. So there's another situation where you might want to do a temporary license because you don't know if the deal will ever close. But other than that, I'm sorry that I even put it out there because then people are going to say Mark Weisletter told them that they can use a license agreement and get around the act. I did not. You cannot. But it's a way to help you when you have a seller that has to stay for a couple of months.
It's a way to help in a particular situation.
Yes.
It's not something to abuse. What can the landlord do if the tenant moves out leaving garbages and without cleaning?
You should be grateful they left, is what you should do. I've had situations, tenants have destroyed the place. They have no money, and it's such a disaster. That's what I say to people. Be happy. I remember I had a closing where the buyers called me at 7:00 at night. When a buyer calls you at 7:00 at night on the day of closing, they're not calling to say, thank you, Mark, for being my lawyer. There's always something. So this one said, there's a strange man living in the basement. He wasn't here when we did the home inspection, but he says he has a verbal lease with the seller and he's not going. What do we do? So I said, call the police. I mean, he's trespassing, but of course they called the listing agent, and within 24 hours, the guy was gone. Thankfully, the guy was gone. But then I was happy. I said, thank you. They said, why are you thanking me? I said, because the next time somebody calls me to say that the burner on the stove is not working after closing, I had an answer. Be happy there's nobody living in your basement that you weren't expecting. Anyways, okay, so I've seen every closing problem. I can handle any closing problem. So that's really, why people come to me. But if you need help with any of these issues, at least I'll tell you. As you can see, I have an answer for all the questions that come up.
If the tenant does not cooperate with showings, can the landlord send the N5 to the tenant?
Yes, but what did I say when I talked about this? You can issue an N5, but it'll take you 6 months to get a hearing. So what's the point of it? What is the point? You're not going to show the property. You're not going to sell it right now. So that's why I try to give practical advice. I don't want you with forms and courts and everything else. I want the property sold.
What is the responsibility of the landlord agent to sign the government lease if landlord not interested?
Well, I think you've got to educate the landlord right away that if they don't sign the government lease, the tenant can turn around at any time and just give 60 days notice and cancel the lease. And to me, that should be in writing, because the landlord's going to blame you if it happens.
Next question is, if the buyer assumes a tenants, can they increase the rent amount?
If the buyer
assumes tenants?
No, the answer is no. You cannot, nobody can raise the rent. No buyer can raise the rent. The rent is the rent. I said earlier, if the tenant leaves on their own, they just leave, then you can raise rent on a new tenant, but that's the only situation.
I'm lost on this next question a little bit. Sorry, this is from Ajax. If the lease starts on 15th of June and next month, rent is due on July 15th, giving the notice is still the end of month?
No, that's a good question. So this is why you have to look at a lease. If the tenant pays rent on the 15th, it means the end of their term is the 14th. So you see, let's say we did a deal today, June 18th, and we have to serve, what did I say, 60 days before the end of a term. So June 18th to June 30th, 12 days. August, 31 days. That's 43. And September, 14 days. That's the end of a term. That's 57 days. So it's too late already to terminate that lease on September the 14th. So the earliest that lease could be terminated today, for the end, they'll call me and say, Mark, we're doing this, and I say, send me the lease and I'll tell you how to do it. But I also say, paralegals know this too. And, that's why you don't do it yourself, or you're going to make a mistake.
A 6-month tenant agreement. After tenant moves in, tenant says, I'm going to move out after the second month. Second month rent is used as her last month payment. Can she do that?
The tenant can't do that. Whether she signs 6 months or a year and they leave, they can leave, but they owe the rent till the end of the lease. The difference here, though, is the landlord has an obligation to reduce their loss. So let's say the tenant just says, I'm leaving. I'm leaving after 2 months. And they go. They owe you 4 months. But you're supposed to go out and find another tenant. So let's say you go find another tenant at the same rent. Then all you could really sue might be the real estate commission for the extra month you had to pay in commission. But unless you suffered a loss, you can only sue for the loss if you're a landlord. So short answer is you can sue for any loss you suffer.
Sorry, I'm just reading through this. A couple of these will we get the presentation? Yes, Mark said earlier that he's going to give us the presentation and I will forward it off. We'll also have this recorded, so you will have access to all of that. Probable cost of a paralegal. Probable cost of a paralegal.
You know, it's not cheap. You know, paralegals who have to do a whole eviction, prepare for a hearing, even though the hearings are on Zoom right now, I've seen costs $2,500, $3,000 for a paralegal to do the case for you. It's not cheap, but that's one of the reasons why I say, write a check. Just write a check, move the tenant out. It's going to be cheaper for everybody.
The names, can you give us the names of paralegals?
I'd rather just do that when you send me an email. Like my email is there, mark@realestatelawyers.ca. You need a help of somebody, just send me an email and I'll give you a reference. I don't really want to just put it out there like this.
If the tenant wants to move out before the lease term ends and don't want to pay compensation to the landlord, what should the landlord do?
I think I answered that already. The landlord can, they still have to try to reduce their loss, but they can claim any loss from the tenant afterwards.
Person applies for tenancy, has good job, good pay, and good credit, but not good attitude. At this point, no agreement is signed. Can the landlord refuse to rent without any consequences?
What's the reason, though, they don't want to rent?
They're just looking at the bad attitude, so they don't want to rent.
Well, you know, it's a difficult situation. I do mention this in my landlord guide, you know, because you don't want to say anything that's going to be considered a human rights violation, that you didn't rent to them because of any kind of race, religious, family status, you understand reason. You have to be so careful how you turn down a tenant. One of the best answers I've always found is just to say, we preferred another tenant. That's it. Don't say much. The more you say, you're just going to get in trouble.
How big is the chance to use N7 form because the tenant causes big damage in the rental property?
Look, you're allowed to use the forms. You can go to the board and collect damages if you can prove them. It's just, you have to ask yourself, are you going to collect the money? Do you know where the tenant works? Or is the tenant just disappeared and you don't know where to find them? So I think, like anything else, yes, you can sue for anything, rent, damages, etc. But what I say to people is, are you going to be able to collect this money from the tenant? You're still going to have to pay the paralegal to do this for you. So are you going to collect the money? If you can't collect, it's the same thing I say to a seller. The buyer didn't close. I'm going to lose $50,000. I want to sue the buyer. I say to the seller, the buyer's a 5% down buyer. They couldn't get the mortgage with CMHC. Listen to me. They have no money. So what are you going to do? You're going to sue them? Yeah. You'll pay lawyers $20,000, $30,000, and you'll collect nothing. Make a deal, maybe get the deposit, get a little bit out extra, and move on. Now, if it turns out the buyer is a substantial buyer, they've got a lot of money, they own a house, then it's different. Well, now we don't have to settle so fast. So you see, you can't give a one-size-fits-all answer for every one of these questions. Should I sue? Should I not sue? You have to understand, are you going to collect any money? Or is it better just to move on and learn the lesson, be a better investor, qualify tenants better before you rent to them?
Is there a time limit on when the tenant can sue after?
There's generally a 2-year time period to sue for anybody for any reason in Ontario. And more and more people now are checking social media when they check a tenant. They check social media, and you should Google the tenant. You should see, just what they're doing with their life, and just see, is this the kind of person you want in your apartment as well? Good property managers do that. They do search on Google, social media, Facebook about the tenant, just to see the kind of people they are.
Someone needs a little bit more clarification. Tenant requests governmental lease to landlord, and if not provided, the tenant can opt out of the lease with 60 days notice, provided only if landlord has not provided the governmental lease. Is that right?
No.
And then otherwise, if lease is provided by landlord within 21 days, then the 12-month lease term is enforced, correct?
I'll repeat myself. You must give the government lease before the tenant moves in, period, end of story. Otherwise, the tenant will be able to terminate. Now, how does the tenant terminate? First, they have to ask for the lease. If the landlord gives the lease, doesn't matter. They can still terminate 60 days later. Let's say the landlord still doesn't give the lease. The tenant has to wait 21 days and then give the 60-day notice. So I'll repeat, in either case, that lease can be terminated early. That's why you give the government lease before the tenant moves in. Then you don't have to worry about this. I hope that was helpful. That explains it.
Yes. This is a good one for you. For my investment property, I have a tenant that was on a 1-year lease. I have the 1-year lease. No, after the 1-year lease, they became month to month, and I have asked them to vacate and agreed to pay 3 months compensation, and they refused. Now they have been missing rent, and when I take them to court, they catch up with rent and the process starts again. What can I do?
Okay, number one, be happy you got paid. That's number one. There are landlords out there that have not been paid for months, and they have to almost default on their mortgage because they don't have the money to pay the bank. You got payment of the rent. If the tenant is persistently late in paying the rent, and they do what your person just described, they catch up at the last minute, you can evict them with a end of term 60-day notice, and the reason is persistent late payments. I've seen evictions when you could prove 8 late payments in a 12-month period. Will that work today with the pandemic and everything else? I don't know, but that would be the only way that person could evict. It would be based on the reason of persistent late rent payments.
Folks, I know you're putting in a ton of questions. I'm going to keep going until Mark Weisletter lets me know that he would like to stop. I see like 70 questions in here, so I'm just going to keep going, and I'll try and get to as many as I can. Do you have to wait for the contract maturity date for rent increase, or can you increase 6 months into a contract when the year changes? Example, after January 1st, 2022.
Since no rent increase was allowed this year, it depends when your lease started. Normally, under the regular rules, you're allowed to raise the rent once every 12 months. So if your lease started, let's say this month, June 1st, 2021, and the government allows increases January 1st, you can raise your rent next June the 1st by whatever the government increase is. So it's got to be 12 months from the start date of your lease.
What happens if the property becomes unsafe to stay in during the tenancy agreement?
Well, a landlord, has to do whatever is necessary to keep a place safe. The landlord has those duties. And so it's not really explained how did the unit get unsafe? Did the tenant damage it, or Was it just unsafe to begin with? But a landlord, you know, you can't have a situation where there's a fire hazard and then somebody dies in an apartment because it was a fire trap. You know, it's a horrible, horrible thing. So, you know, yes, landlords do have obligations, but so do tenants. You know, they can't just destroy a place and make it into a unsafe situation.
So a tenant wants to leave as they purchase their own home, and landlord agrees verbally to let them leave like next month. What written document would be needed to settle that? Is the question.
Well, verbal agreements don't mean anything. And until the sheriff is allowed to enforce an eviction, nothing means anything. That's why I said, write a check, but don't pay it until they're partway out the door. Sometimes I've had to deal with large checks. And so we've had to make a deal that I would pay the check to the lawyer for the tenant. And the lawyer wouldn't give it to the tenant until they left the place. So sometimes, depending on how it is, you got to get other people involved. But you got to use common sense. Just because somebody verbally says they're leaving means nothing. Means nothing.
Here's a good question. Why is everything seem like it's against the land?
You know,
I was going to ask that question.
you know, it's funny that for every complaint I get from landlords, I also get complaints from tenants. Think about all the tenants that were tricked into leaving so landlords could double rent. Think about the place in Kensington Market a couple of years ago, where there were 8 tenants living there. They each were paying $1,000 a month rent. And the landlord said, I'm going to renovate the place. Now, under the rules, if you're going to renovate the place, you have to let the tenants have the right of first refusal to come back when you're finished at the same rent. This landlord spent 2 years fixing the place up. It was beautiful. The tenants all came back and said, looks great. We're ready to come back. And the landlord said, well, I'm very sorry, but I've already signed 8 new leases, $4,000 a piece with new tenants. I can't give you the place back. And the tenants took them to the board, took them to court, and the judges said, well, we feel bad for you, and we might give you some damages, like, 6 months rent, but we can't put you back in because we can't end those leases. And this was called a renoviction, and not so easy to do those kinds of tricks anymore. So you see, for every trick that landlords complain about now, tenants have always complained that they were being abused. And so it's not, that tells me in general, things aren't so terrible. But what we will see, you'll see things even out when we get out of the lockdown. Once the tenants realize that, this game is over, things will be better. And I don't want to give you the impression that every tenement is terrible. A lot of the times, the reason the tenant won't go is they're paying below market rent and they can't afford to go anywhere else. They can't find a place for a similar rent. That's the challenge. That's why it's so hard to do this. You've got to help that tenant find another place to go to, pay the difference in rent, maybe for 1 to 2 years, because that's the biggest problem. It's not that they're bad people. They just don't know where to go. So I don't want, like I said, things will start to get back to normal as we all come out of the lockdown and, start to live more again.
Where can we find the new government lease? Somewhere specifically?
Just go online. New government lease. You can download the government lease. It's available online.
If a landlord served N11 and gets it signed by the tenant, the landlord has doubt that the tenant will not leave on the date decided, what will be the best approach in this case? Can L2 be applied right away after N11 signed in landlord and tenant board?
Yes, I said that earlier. It's been that way for many years. Let's say the tenant said they were leaving today. June 18th. It's Saturday, tomorrow, June 19th, tenant's still there. The landlord on Monday could file, I think it's the L3, right away with the board by fax saying, here's the agreement. The tenant's still there. I want an eviction order. And you will be able to get an eviction order usually within a couple of weeks. The problem is you have to take that eviction order and go to the sheriff. And the sheriff is not completing anything right now. But you can apply for that order right away on the day after the tenant was supposed to leave.
What about the landlords who are asking for first and last month's rent and deposit? Can we tell them it's illegal, and how can we take action against them? This is for basement room rentals.
See, the difficulty with all of this, I think you're talking about a security deposit. They want an extra month security deposit. So the landlord wants first and last and a security deposit. And it's not legal. If you start up right away and say, I'm not paying a security deposit, the landlord is just going to say, go away, I'm going to rent to somebody else. So right away, you're not going to get the place. So what are your rights as a tenant? You could pay it. So you could pay this extra month. And the day after you move in, you could say to the landlord, you charged me with an illegal security deposit. I want the money back. They could do that. Now, they have a poisonous relationship with the landlord right from the start. The landlord hates them. And if you're going to need a favor, you're going to get nothing. So what do I say to the tenant? Look, why don't you look at it this way? You paid the landlord the first month's rent and 2 extra months. Whenever you want to leave this place, the law says you have to give 2 months notice anyways. So when the time to leave, why not just say to the landlord, remember that security deposit you took from me? That's my second last month's rent. And there's nothing the landlord's going to be able to do. It's your second last month's rent, and you don't have to pay anything when you leave. So that's my advice typically with this security deposit, because look, tenants need a place to live, whether it's legal or not. You're not going to get the place if you don't pay it, but that would be my advice. So at least you can move in and not forfeit it in any way. You'll use it, but it'll be used as your second last month's rent. So I'm not saying you couldn't ask for it back. You could. You're entitled to it back, but now the landlord hates you. You really want to start a relationship with a landlord that way. I wouldn't recommend it.
If parties agree to a repayment plan, but then the tenant moves out without paying the remaining amount, and the landlord, if desired, would go to the small claims court, correct?
You could go either way. You could get a judgment from the landlord and tenant board. You can get a judgment in small claims court. If you know where the tenant works, then you can go garnish wages. You know, you can do whatever you like. You can collect the money if you know how to collect it. Like, you have to know where the tenant's working if you want to garnish wages.
This one's just a comment. This was a very helpful session. Thank you.
Thank you. You're very welcome. That's why people come to me, and I'm happy to help all of you. I already see a bunch of people have asked to order my landlord guide. It's only $50, and it has everything you'll ever need to know. But I already see people have sent me emails. Yes.
So if we don't have any lease with a tenant, but he's been living there for 5 years, and now he's not leaving the place, and we have a few police complaints against him, what should we do now? Should we hire a paralegal or a lawyer?
I think when you get in this state of police stuff, where it's an emergency type situation, sometimes there's drugs and other stuff, then you may need an emergency kind of application. In those situations, I would recommend somebody go to see a lawyer who's done this before, who's got expertise. It'll cost more, but it's an emergency. That's where I sort of draw the line between, paralegals and lawyers to help you out.
Can we use the license agreement for a tenant that fails to leave?
No. I'm sorry I even mentioned it. I did it to help you, And now it's going to be abused all over the place. So I don't even want to hear license. There's no such thing as license. Forget it.
Forget it. Reason we have too much money. I guess the best thing is rent the place through Airbnb. The payments termination date are all safe. What do you think? Huh? I guess the best thing is rent the place through Airbnb. The payments, the termination date are all safe. What do you think?
Oh, in other words, you're doing the entire process through Airbnb platform. Then I think it's much more difficult for the tenant or for the guest to say they're a tenant. When you're doing everything in the platform, then I think you have much more protection than if you make a private deal with somebody.
Tenant is asked to sign a 3-year lease with an option to terminate after 1 year with 9 months notice. The standard lease is signed. Can the tenant still give 2 months notice not to be in violation of lease agreement?
There's a lot of issues in that thing, which would be difficult for me to comment on right away, because you're not allowed to change the law with a lease. You're not allowed to change the law in a lease. So as an example, you can't say in a lease, no dogs, if the province allows dogs. The act allows dogs. So unless a condominium said no dogs, that you could put no dogs in the lease, but it's not legal. Similarly, you can't start fooling around with termination notices that are against the act. So depending on what it says, I don't really want to say one way or another now, about this. When people say, how do I know? The tenants lie about dogs. They do. And the reason they lie is because they know if they tell the truth about a dog, then they won't get the apartment. So I get same complaints from tenants, same complaints from landlords. But even if the tenant lies, you can't kick them out if they bring a dog. I'm going to close with one story because I have another appointment. So I wrote in an investment guide about the dogs. I said, check Facebook. If this person has a dog, you'll see them in the park with the dog, and then you'll find out in advance. So I got a call from an investor 2 months later. She read my article and she said, I read your article and I rented my house a few months ago in Hamilton, but I decided to Facebook the tenant. And on Facebook, she was standing in a picture with this humongous pig on a leash. And so she said to me, is there a pig living in my house? So I said, I don't know, but you're allowed to go check the house if you give 24 hours notice. I don't think she gave 24 minutes notice. I think she ran right to the house. She called me up the next day and said, I went to the house. In one of the bedrooms, in one of the beds, sleeping, was this humongous pig. And she wasn't talking about the woman's husband. And so she asked me a good question. Can I evict because there's a pig in my house? And I said, I'll tell you honestly, I'm not as familiar with the bylaw in Hamilton. Go check at the city. She went. She called me back. And you have to understand, I'm laughing my head off through this entire conversation. But she said, in Hamilton, a licensed pig is permitted as a pet. There was nothing she could do. So again, I said, thank you very much. And she said, why? Because next time somebody calls me and says there's a dog in my house, I say, be happy. You don't have two pigs sitting there in your house right now. So the lesson is check Facebook now, check social media, check to see if somebody's a bad tenant and cheats people. That's how you do it. And so I did want to close by thanking everybody. Thank you for the comments I'm getting on my on my emails, marketrealestatelawyers.ca. I will send the deck to everybody. I hope you enjoyed it. And if your clients need any help with any closing or any question, please mark@realestatelawyers.ca. So thank
Mark,
you.
I'm putting that email address in the chat for everybody to just get it just in case really quickly. And is there a phone number that they can reach your offices?
Yeah, I've given you my numbers. They're all in there, but it's 416. I prefer an email, by the way, because it's easier for me to get to an email. But,
perfect. And I'll just do that.
But it's on the material. 416-702-2499. There's toll-free number on there, but email is the best way to reach me. Okay.
Perfect.
So I want to thank everybody.
On behalf of everybody here on all of HomeLife, thank you so very much. It's always a pleasure to have you.
Thank you. It's my pleasure. I hope it was helpful. I hope it was helpful to everybody. Thank you very much.
Thanks a lot. Thank you, Mark.
You're welcome.
Thank you. Bye, everybody.
Bye, everybody. Great session.